Welcome to Criminal Law's first interactive lesson. And in fact, it's my first interactive lesson. First time making a video with slides to go along with it, which is pretty nifty. But give me feedback. I want to know how it goes. So today, we're going to be looking at criminal law, first homework from your online text. Have your online textbook handy. That'll help us when we go over it as well. Have your homework handy too, so you can look at what you wrote. Remember, you can always pause this video, look back at what you wrote, and have a greater insight into what we're talking about now. Also have your notes handy. There's going to be times when I tell you to write down something in your notes, and that's going to make class a lot more exciting because you'll be ready to talk about the stuff you wrote down while you watch this on your own. So earlier, we looked at what criminal law is. On the first day of class, I said criminal law is the study of crimes and the principles of criminal responsibility. And that's a good start, but it doesn't tell us what crimes really are. So let's look at that. A couple definitions you might consider. One I pulled off of Wikipedia. Crime is an unlawful act punishable by a state. Another? Well, we'll look at that in a second. But first, think about this. Does this leave out anything that you already know crime is? An unlawful act punishable by a state. Try jotting down in your notes any guesses you have. Is there something that could be left out? Another question worth asking for any definition is, does it include too much? Because a definition that includes too much isn't a great definition either. Does this leave in stuff that shouldn't be left in? Let's look at another definition. Cornell University says crime is an act or omission of an act in violation of a public law forbidding or commanding it. And that actually comes closer to the definition that you see in your textbook too. So some things worth considering. Wikipedia's initial definition, and they had an article they went on to explain in greater detail, but their initial definition leaves out an omission. When you omit something, you don't do it. If you can think of anything you don't do that might end up resulting in you being charged with a crime, then you know Wikipedia's definition might not have been perfect. It might have been a little too narrow, left out some good stuff. Another thing worth thinking about, whether it includes too much, is this, and this could be true for the Wikipedia definition or the Cornell University one. If it includes stuff that government can punish you for that isn't a crime, then it's not a perfect definition. And there might be some stuff government can punish you for that's not technically a crime. Like sometimes if companies pollute, they have to pay a fine. That's generally considered to be a civil law violation. We'll talk about civil law later rather than a criminal violation. To be continued. Let's start with some easier definitions though. Bird, chair. In your notes, pick one of these words, bird or chair. Make up a purposely bad definition, or you can try to make a good one, but the purpose is that we're going to look at the definition you make and kind of pick it apart. So don't feel any pressure to be perfect here. Write in your notes a definition of bird or chair. In fact, both could be great to write down. Remember, you can pause the video at any point to try this stuff, and that way you can just come back. Look at your definition and think about whether it includes too much or leaves anything out. If you said a bird is any animal that can fly, that might include too much because bats can fly. And if you said a bird is any animal that can fly, it also includes too little because it's not including birds that don't fly, like ostriches. The same is true for chairs. So I'm excited about looking at what you wrote in class and seeing your thoughts on whether your definition includes too much, that is, it's too broad, or too little, too narrow. If a definition is too broad, you can prove that by saying what's included that doesn't belong. And that's what I did earlier with birds. I said my definition of bird, any animal that can fly, is broad because it includes bats. I proved, or at least began to prove, my definition was broad. And if it's too narrow, it leaves out stuff. That same definition is both too broad and too narrow. How do you prove something's too narrow? Say what should be included but isn't. Birds are any animal that flies. Well, I'm leaving out the poor ostrich. That means my definition is also too narrow. So when you make good definitions, That lets you make good law. And when you can understand how to do that, you can play the role of a lawmaker. All year long, we'll be talking about how to define crimes and how to argue that in court. That'll help us decide when a defendant is guilty and when they're not. And that's really key information. When we look at criminal law, we'll be looking at substantive criminal law and procedural criminal law. Notice we've gone on to a new section of the book. And in your notes, I think it's going to be helpful to look at that top left-hand circle, which now says 1.2, because it'll tell you how your notes connect to what you've already read about. In fact, when you take your initial notes for homework, you could even leave space to add to it based on what we talk about in class and any interactive videos we have. So, substantive versus procedural law. Substantive laws define what's illegal. They may also say the punishment. Murder's against the law, and if you murder somebody, we're going to cut your feet off. That would be a substantive criminal law. We looked at an example in class the other day that was religiously based, and this little image might remind you. If we say, thou shalt not kill, we are setting up a substantive criminal law. That is a rule that's in place. As long as it's a government doing it, it's a criminal law. A rule that's in place that says what not to do. There's other rules on that list, and some of you might know about some of those rules. They're not criminal laws unless a government puts them into place, but many governments do when it comes to killing. Procedural laws define how government treats you if you're accused of a crime, from the cops all the way to the courts. So if you ever see the Miranda rights, and take a close look at this, you can pause it and see if you want. These will look familiar. These are procedural rules put into place to tell officers of the law what they must do and how they must inform anyone who is questioned by the police. You have the right to remain silent. Anything you say can well be used against you. The procedural criminal law is the rule that says you must inform people of their rights if you're about to interrogate them. And that's key. Our focus this year is mostly on substantive criminal law. We're going to look at what's illegal now and how that's changed over the years. Those changes can be pretty interesting. And we're also looking at how it differs from place to place. One big truth I want to make sure you remember is that we are a nation with 50 states, each which can make their own criminal laws. So whenever someone tells you something's illegal, remember you can ask, where? Where are you talking about? Unless you're talking about a federal law at the national level, then there's a lot of choices. But we'll also look at procedural law when we study your constitutional rights, and that's coming up soon, actually. So let's look at crime. We looked at these definitions earlier, and it's worth thinking about. Criminal law is the stuff that government wants to punish you for because you've harmed the community, is the idea. I think there's some things that aren't actually as big a harm to the community as you might think, like speeding. Why is that a crime? But potential harm in creating a risky situation is something governments consider. Some kinds of law deal with just private harms. And that difference isn't always clear. I don't want to pretend it's too black and white. But that's how you tell the difference between criminal and civil law. You look at whether the government's prosecuting someone for a crime or whether it's a situation where a private person or company or even government, weirdly enough, can sue, but not to put you in jail, not with criminal consequences, instead with civil ones. That difference might not make perfect sense yet, and that's okay. Let's look at it a little more closely. We'll talk about it. If you already know any civil law examples, it's a great time to write some down. O.J. Simpson. He's a great example of someone who went through both a criminal trial and a civil trial about the same incident. And in the 90s, his criminal trial, he was charged with killing his wife, Nicole Brown Simpson, and her friend, Ron Goldman. His trial, made all the headlines in the world. And you might very well know about this because more recently, in the 21st century, there's been documentaries and kind of fictionalized shows based on the O.J. Simpson story. It keeps going. First, he was charged with a crime. And this picture kind of shows a picture that's famous from the trial. His lawyer got him to try on the gloves that were found at the scene. They didn't fit. The lawyer said a line that you might know. If the glove doesn't fit, you must acquit. That is, find him not guilty. There's some reasons why blood-stained gloves might not fit perfectly when the defendant puts them on. They dry up some when there's blood on them, and you can always hold your hand in a way that makes a glove hard to fit on. But that wasn't the only reason jurors in the criminal trial had some suspicions about the case the officers were making. It turned out one of the officers was profoundly racist, had been recorded saying racist things and tampering with evidence. And O.J. Simpson's defense team said, what if they tampered with our evidence? That could be why some things make him look guilty, but they aren't real. That was enough in the jury's mind to say that they could not convict O.J. Simpson. It did not hold him guilty. That doesn't mean they think you're innocent necessarily, but it does mean they think we can't prove you're guilty beyond a reasonable doubt. Of course, later on, he wrote a book called If I Did It that went into a weird amount of detail about exactly how he would have killed them had he done it. And that took away a lot of people's goodwill towards O.J. Simpson. But a civil trial that came later, one in which the family of Ron Goldman sued him, that trial he lost. Partly because there were different stakes at play. If someone sues you, you don't go to jail when you lose. It's not government prosecuting you. And if someone sues you, it's not as hard for them to prove their case. They don't have to prove you guilty beyond a reasonable doubt. Instead, they just have to prove that it's more likely than not that you did what they claimed. They call that the preponderance of the evidence standard. Just tilting towards their case is enough for them to win. Whereas in a criminal case, proving beyond a reasonable doubt means they've got to take away any remaining doubt in the jury's mind, at least a reasonable one, that the defendant might not have done it. Maybe that's a 90% proof rather than a 51% proof. And that burden is pretty different. So let's look at issues involved in criminal versus civil law. In your notes, write down some issues you can think about for crimes. What are some crimes you know of? And for civil law, what are some reasons you might sue someone? I've discovered, and there's a lot of research to back this up, that if you make your brain search for stuff before I just tell you, you remember it much better. It sticks in your head more. So that's why I tried this out, even in these interactive videos. Here are some examples of crimes: murder, stealing, setting things on fire when you're not supposed to. Civil law, when you get divorced, you used to have to sue someone in court and claim they cheated on you or abused you. Now it's a lot easier in most states, but it's still a matter of civil law. Someone invades your privacy or uses your copyrighted material. Those can be civil law matters. The parties involved sound similar in one sense. There's a criminal defendant and a civil defendant. The person who is sued is a defendant in civil court, and the person who's charged with a crime is a defendant. But the other party is different. In criminal law, we have a prosecutor, which is always the government. In civil law, we have a plaintiff who sues, and that could be the government, an individual person, or a business suing another government person or business. That is, one state could sue another state. A person can sue their insurance company, or they can sue their neighbor if their neighbor keeps having their dog poop in their yard and they want him to stop. Not a crime, but perhaps a matter where a civil court could decide things. What are the results of the two cases? They can be pretty different. What's the worst thing that can happen to if you lose a criminal case? You could be killed. You could be put to death. Results include death, imprisonment, or fines. You can lose your life, your liberty, or your property. And you might remember, if you've had this in a different class, like those are the three natural rights that John Locke considered every person has. In our Constitution, it says government can't take away your life, liberty, or property without due process of law, without going through a certain procedure that respects your rights in order to take them away. And we'll look at that too. In a civil court, the consequences are different. That is, you might have to pay damages. We don't call them fines because it's making up for what you did to someone else, and they call it damages in civil court. You might have to obey an injunction, an order from the court to do something or stop doing something. And like we said, the standard of proof is different. In a criminal court, beyond a reasonable doubt. In a civil court, the preponderance of the evidence. There's another thing worth considering. And look at this picture. Jot down in your notes what you think is going on here. This is a picture that will lead us into a discussion of the very first step before a criminal case begins. It's your right, federally, and states tend to ensure this as well, to have a grand jury hear the evidence against you before you're brought to trial. That's different than a regular jury. We're not talking about the jury you probably know more about that actually decides whether you're guilty or not. A grand jury is a different group. They decide whether to bring you to trial at all. The reason why that's a right of yours is because the writers of our Constitution didn't want you to have to be drawn into court, to face trial, to lose your time, your money, and risk your freedom being taken away every time the government wanted to go after you. And the government had to have a good case instead. So they go before a grand jury, make their case, and the grand jury decides, is this enough to bring the person to trial? They don't decide if you're guilty, but they do decide if it's enough to bring you to trial. And often they're told, if everything the prosecution said is true, would it be enough to convict? Well, then we can let the trial begin. The defendant can make their case, and we can see if they actually will be convicted. This picture is from Ferguson, Missouri. People were protesting because a police officer who was accused of using excessive force that took the life of Michael Brown, this police officer was not indicted or charged by the grand jury, did not go to trial. And this is a complicated case, more complicated than some of the other cases of accused police brutality that we've seen in recent years, but it's one that sparked protests because he wasn't even brought to trial. Generally speaking, a good prosecutor, someone who works for the government and wants to charge people with crimes, can convince a grand jury 99% of the time. Let's indict. Let's charge the person and bring them to trial. But when it comes to police officers, very often, grand juries do not indict. They don't charge the person. They never go to trial. There's some reasons for that. One is that the law makes it harder to convict a police officer who is acting in the course of their job and uses violence that was a wrong choice. Even a wrong choice could be seen as reasonable and not get you convicted. And because of that, sometimes you're not even charged. Whereas a regular person who shoots someone in the street doesn't have as much reason to say, hey, this was a reasonable choice. A police officer can sometimes say, I'm allowed to use force. I did it wrongly here, but I meant well, and the choices I made were reasonable enough despite being wrong. That is, if I shot someone because I thought they had a gun and it turned out they had a cell phone. A lot of critics, though, say that standard is too easy on police officers, that we need to hold them to a higher standard, partly because of their job and their training, partly because of the deadly consequences when they act wrongly. And we'll look at that this year. But remember, the first step before bringing someone to criminal trial is to convince a grand jury to indict them. In a civil case, something different happens. You need what's called standing to sue. So you can't bring just anyone into court. You've got to be able to argue to the judge, I have an injury. Could be an actual physical injury or something different. Or I'm about to. You can sue to stop something from happening. That it's the defendant's fault and the court can fix it. I want you to think about that. All of those things are required to be part of an argument you make to the court in order to even sue someone at all, because you don't want to be able to have the right to just sue anyone you want anytime for stupid reasons. That'd be pretty hard on a person too. Maybe not as hard as facing frivolous, stupid criminal charges, but still pretty tough. So think about this and write an example in your notes. If I slip on some water at the grocery store and fall down and decide to sue the grocery store, in order to sue successfully, to have standing, I've got to make a good argument to the judge that I've been injured, it's the defendant's fault, and the court can fix it. Think about an example of where I might not have standing. That is, pick one of those three things and say, oh, what if you fell and this was also true? Add some details. We're going to be making up scenarios all year long. And your creativity, imagination, and willingness to try things out, even if you aren't sure, is going to make that a lot more exciting. So try that out with the grocery store example. Remember, you can always pause this video, by the way. So I'm interested in sharing what you found in class. Remember, you don't have to prove these things to a judge in order to sue. You just have to make a good argument. The point of the trial is the proving. The point of trying to get to trial is to show you at least have a good argument set up. So if I were you, I would have a nice table in your notes with all of these things. Remember, you can go back and look at this again if you've got questions about it. But remember, the first step to a criminal trial is a grand jury, and to a civil trial is to have standing to sue. Some people say that unlike civil law, criminal law brings moral condemnation with it. That is the community saying, we disapprove of you. Might be worth thinking about where you would question that. Part of that's just a skill I want you to try out all year. Push back against statements of subjective opinion about the law. Where could you tease that statement and maybe find some ways to undermine it? Try that in your notes. Anything you can think of. So the other day we looked at levels of seriousness of crimes. We started with a felony and we said, generally, if you kill someone, it's very likely you've committed a felony. We looked at trespassing as an example of what might be a misdemeanor, a milder crime, and jaywalking, even when the sign is up, as an example of an infraction, a crime that doesn't come with any potential jail time at all. Make sure you know the differences between those. The key thing to remember is this, and here's Virginia's felonies and misdemeanors and the possible range of sentences. Here's what's good to remember. In general, states define a felony, there's my cat, as a crime with a maximum sentence that is over a year and that could send you to prison. That's the maximum sentence. Most crimes come with a range of sentences. And that means that even a felony could have a lower minimum. Someone could commit a felony and get 8 months in jail. Prison's where you go if you're more than a year behind bars. Notice that for every single one of these felonies, prison is possible. Over a year is possible. And for every single one of these misdemeanors, it's not possible. That's the difference. It's not the sentence you actually get, because you could get less. It's the sentence you could get at maximum. And notice that's a fair amount of money for the most serious felonies. We'll look at Virginia law a lot this year, and I'll give you a good bookmark for it later too. There's the key takeaway. Want to know the difference? Look at the maximum possible sentence. So we've been looking at levels of seriousness in crimes, and one thing that can relate to that is whether they're morally wrong or not. Your book talked about mala in se, or what they called malum in se. They use the singular in Latin, crimes, which are bad in themselves, seen as morally wrong. Other crimes are called mala prohibita crimes, or malum prohibitum in the singular. They're bad because they're prohibited. These are both categories of crimes. They're just ways to divide crimes between morally wrong and, not morally wrong, just something we decide to ban. You could ban something for a reason you think will help with order and security without necessarily thinking a person who does that act is a bad person. But this is a matter of opinion, which means as long as you can make an argument that shows you know what the terms mean, you're in a really good place. Try it out. Think of an act you think of as legal, but you believe is morally wrong. That if it were illegal, you would call a mala in se crime. Now, take something that's illegal, but you believe is not morally wrong. That is something that's a mala prohibita crime. There's a lot of different factors here we're talking about, but I think it can lead to interesting discussion. If you have in your notes at least those two examples, and you could think of more things, things that you want to ban that are currently allowed, things you want to allow that are currently banned, and look at whether those things are morally wrong or not in your book. Just as an example, I think it's legal to butt in front of someone in line at the amusement park. Generally speaking, I'm not committing a crime if I walk up to the roller coaster, push past some other people, as long as I don't push them too hard, and move to the front. But I do think that's morally wrong. I disapprove of that person. Anyway, I'm interested to see what you write down in your notes. Make sure you do. We'll talk about it in class. There's some skills here. You're thinking about how you might want to change the law, and legal reform will be on our minds all year. And you're also practicing thinking of reasons to back up your claims, making arguments. What should be a crime in general is a related question. Try this out, and it's perfectly fine if it feels a little unsure. This is a question people who write laws have worked on for centuries, millennia even. But I'd love you to come up with an initial statement of what you think should qualify an act as illegal. An act should be made illegal if. Think of some rules in place. This could be just your own opinion. I think we should make things illegal if they cause this result or are done with this mindset. Anything you put could be good food for thought in the beginning of a conversation. Next, take a look at this story. I just happened to read this in an actual advice column and thought this will make an interesting story. And I illustrated with a picture from an old movie. It's about someone who said, "My neighbor told me she accidentally killed her mom. Am I breaking the law by not telling anyone?" Pause it, read the story in more detail, and then write in your notes whether you think keeping this secret should be a crime. Think about arguments you could make on both sides. This is a skill in criminal law, being able to argue both sides of a case. It doesn't mean ignoring morality and what you really believe, but being able to step into the other side's shoes can be really helpful. Pause, do that, and then we'll move forward. So this next discussion might seem like a quick change of topic, but we're going to come back to that lady who accidentally killed her mom and the neighbor who knew about it. But first, make a table in your notes that clearly lays out the 4 justifications for punishment we read about, why we punish. I want to make sure you have clear definitions down and examples. And one thing that's worth repeating is this. These are justifications for punishment. That means reasons we punish. These aren't types of punishment. Even though they might make you think about particular types of punishment, each one could be a reason we give for the exact same punishment, which is interesting to think about. You could have 4 different reasons with the exact same punishment. 3 of these reasons are about what we think the punishment will do, a result it will bring about, and one of them is not. Circle the one you know isn't about the results, but instead is just about punishment for punishment's sake, if you know it. So some detail. Let's look at deterrence first. Why? Just because I picked that. I found this picture of 2020 Indonesia, where some people who refused to wear masks during the pandemic were sentenced to dig graves for COVID victims. I think one of the reasons for this punishment might be deterrence. Deterrence means in order to keep someone from committing a crime, make the punishment so unpleasant that they don't want to do it again. Notice I focused on the person who commits the crime not doing it again. We call that specific deterrence. A lot of people say deterrence has another goal as well. That is, deterrence is a goal, but there's another kind of deterrence, which is getting the rest of the community not to commit that crime because they see how unpleasant it is. That's what we're thinking about. Specific deterrence versus general deterrence. Are we just trying to make the criminal not commit a crime again? Or are we also trying to make the whole community see how bad the punishment is and try to avoid it in the future? In your notes, make sure you have a clear understanding of deterrence. that you can define it without using the word deter, because that's key to any definition. Don't use the same words again. And also think about this. You can just jot this down kind of next to this part of your notes on 1.5 about justifications for punishment. What's one other reason from our list of 4 that this particular punishment might be in place? I'm interested to see if you can make an argument for another reason other than deterrence. Incapacitation. That means keeping people physically from being able to commit a crime. That could mean locking them up. That's the most common example. I showed a picture of 2 people who were locked up in Florida, and they still are, as of this video. I checked 5 years after the picture was taken. At that point, one of them was the youngest woman on death row in the whole United States, and the other one was the 3rd youngest. They were in their 30s. They were on death row, which is another form, when the execution is carried out, of incapacitation. If you kill someone who's committed a crime, they absolutely cannot commit it again. You've incapacitated them even more. And there's other ways to incapacitate than locking someone up or killing them. Some older cultures would cut off someone's hand who stole. And among other things, that would incapacitate them from stealing again. I want you to think about any other purpose of the death penalty other than incapacitation. Try that out for all of these 4 justifications we look at. I want you to think about, what's another reason the same punishment could be carried out? Let's look at rehabilitation. This adorable picture of a puppy and a prisoner is part of a program in Florida where they partner at-risk dogs, who often were rescued from tough situations, with people in prison, with inmates. One of the goals is rehabilitation, to make the convicted person better than they were before. Teaching them to care, to love, that they are capable of nurturing something else, a living creature, is a way to make someone a better person. And it seems to work sometimes. Nothing's foolproof, but there seems to be a real rehabilitative goal there. And our prisons don't always seem to have that goal. We might call them correctional institutions, but a lot of times they seem to breed more crime and to dehumanize people, so by the time they leave, they're even more likely to stray from legal actions into a path that leads them back into prison. Think about if there's any of these other 4 reasons that a prison sentence that includes puppies could be part of someone's punishment. Last one to look at is different than the other 3. Instead of saying that this reason is because we want to bring about a result, deterrence, scare people off of the punishment, rehabilitation, make them into better humans who don't want to commit crimes because they're good now, or incapacitation, keep them from committing crimes because they physically can't. Retribution says we don't have a goal. Punishment is for the sake of punishment, because the convicted deserves it. There's an ancient piece of writing about this reason that says even if the world were going to end tomorrow, we would still execute everyone who is sentenced to death today, if we believe in retribution, if we believe that they deserve it. Now, I have pretty serious qualms about the death penalty myself, but if I were someone who believed that the death penalty was just and deserved because of retribution, then that would mean I wouldn't care if the world was ending tomorrow. I'd still want to carry out those sentences because they deserved it today. Saudi Arabia ended its public flogging in 2020, but other nations like Iran, for example, still will publicly flog someone. They deserve the pain of it, is one reason government puts forward. See if you can think of another one. Why else would public flogging happen? So let's look back at that case of the neighbor who knew that her neighbor had killed her mom. Pick one of the 4 justifications for punishment and consider, does punishing someone who knows about a crime and doesn't say anything fit one of these justifications for punishment? You can make an argument that either it does or doesn't. So let's say you picked deterrence. You could say punishing people who keep secrets about crime, this could help deter others from doing the same thing. And here's why. Or I don't think it works. I don't think it really helps deter. And here's why. That is, you can pick any one of these reasons to punish and examine whether punishing secret keepers, people who know about a crime and say nothing, will actually meet that justification, will accomplish that goal. Try that out in your notes, and we'll talk about it in class. That's the end of our presentation. I hope that it was helpful. And remember, you can always fast forward through the easy parts, go slow through the parts you want to hear more about, and go back and look at things too. See you next time.